All rise.
Yes, Mr. Baker.
Before leaving the topic of third state, Lord, I was wondering whether the court would be assisted by some consideration of the rationale for the interpretation, or whether that would be unnecessary, given what we say is the absolutely clear meaning of the phrase.
Well, you've taken us quite some distance. I think let's see how the case progresses. I think you can move on to the next topic.
I've got one question. How would it work if it meant another member state?
In Brussels, in the Article 12?
Yes. Because you can't have, as between member states, it's a first-in-time rule, isn't it?
It is. There is the first-in-time rule. And in addition, of course, there's Article 15.
Yes.
And which is, as I understand it, and Your Lordship will know better than I, is an entirely novel provision, or of a type which is unknown elsewhere in international law, for consensual transfer between. No, it's not. That's not right, is it? It's certainly unusual. Consensual transfer between one jurisdiction and another.
I thought it's 19.2 gives a first-in-time rule.
Yes.
15 gives a transfer power.
Yes.
And so there's no room for 12.4 to apply to member states.
Well, if it did, there would be a danger that no state would have jurisdiction, potentially.
Yes.
Now, why is it in this format? Well, I'm not sure I have the answer, but so it may well be it would be a waste of time to seek to try to explain it. The obvious point is that in the enlarged community there are a very large number of people of a wide variety of nationalities. Living within the citizens of member states living in other member states, and citizens of non-member states living within the EU, not least the substantial number of Pakistani citizens or people of Pakistani descent living in this country, and amongst many others. And they are entitled to the same consideration when looking at the overall purpose of the regulation, to facilitate the creation of an area of freedom, security and justice. They are entitled to the same rights as all other persons within the EU, as part of the overall goal of the EU in achieving a free movement of persons.
Just going again to paragraph 4, where it says a third state, which is not a contracting party of the Hague Convention. Just a footnote to our previous discussion. If the state is a party to the Hague Convention, is the position that the same position exists under the Hague Convention as exists under the regulation, or what?
Well, no, because the Hague Convention is a matrimonial convention.
So what's the rationale of limiting paragraph 4 to third states not a contracting party?
Well, our case is that 12.3 applies to all children wherever habitually resident, and 12.4 creates the deeming provision, which we'll come on to in a moment, in respect of children who are habitually resident in a non-Hague Convention country.
I suppose your basic point about rationale is that if you've got parties who are in the EU, or in a member state of the EU, and they want to use the courts of the jurisdiction where they happen to be in order to decide the future of their children,
yes,
why shouldn't they?
Exactly, and that that right is something which should be enjoyed by all persons resident within the Union. Those who are citizens of member states and those who are not but are resident and working here. It's entirely consistent with the aims of the EU for the free movement of persons.
There's no one who knows more about this than Professor Allegria Borras.
Yes.
She says another rule related to the 1996 Hague Convention is paragraph 4 of Article 12, which aims to solve what I have always considered an artificial problem. The objective of the rule is to clarify that Article 52, I think that is of the Hague Convention, doesn't affect children who do not hold habitual residence in a state party to the Convention, which is obvious. However, the solution for those cases is somewhat strange, because after having clarified that the Hague Convention does not apply, it then adds that it will be presumed that jurisdiction under that article is in the interests of the child. A disposition which has been qualified as an excessive exercise of communitarization of judicial jurisdiction related to the supposed interest of the child, then citing some other Spanish material.
Well, it does. There are issues of comity,
Yes.
Which Ms. Russell relies on, and they are recognised in some of the academic discussion. But in my submission to the court is that the meaning is absolutely clear. Whether it is within the it is arguable as to whether it's within the competence of the EU to have done what it's done, but it has done it. And in my submission, it's absolutely clear. I wanted to go back to try to just explore, without having the answers, I'm afraid, my lord, total answers, the interconnection between the 1996 Convention. And that, again, involves looking at Dr. Borras's report in 1998 and having the Hague Convention and the regulation open. The Hague Convention is at tab 4, isn't it, in volume 1. And Article 10 on the third page provides an equivalent to the article, to the Brussels 2, i.e. non-revised, original Brussels 2 provision. In other words, a prorogation in respect of a child habitually resident in another contracting state. So without prejudice to the previous articles which established the basic jurisdictional rules, your authorities of a contracting state under the Hague Convention exercising jurisdiction to decide upon an application for divorce or legal separation of the parents of a child habitually resident in another contracting state, or for an annulment of their marriage may, if the law of their state so provides, take measures directed to the protection of the personal property of such child if, at the time of commencement of the proceedings, one of his or her parents habitually resides in that state, and one of them has parental responsibility in relation to the child, and B, the jurisdiction of these authorities to take such measures has been accepted by the parents, as well as by any other person who has parental responsibility in relation to the child and is in the best interests of the child. And then the jurisdiction ceases, and you will see the similar terms. If we compare that with Brussels, we've already looked at Brussels, the original Brussels 2, at tab 6, you'll remember that that is in very similar terms to the Article 3, 2.
Yeah.
Now, Dr. Borras's commentary about this is quite interesting. At tab 9 in the same bundle, This is Dr. Boris's report, in case it's not clear, is the explanatory report prepared for the convention. I should explain, we jumped ahead of this morning, but initially, the plan was that the new EU rules and procedures about jurisdiction and recognition and enforcement of matrimonial cases was to be the subject of a convention rather than a regulation. But in the event, the draft convention was converted into a regulation. I'm sure I use inelegant and slightly inaccurate language, but that's what happened. And this report is an explanatory report for the convention that became the regulation, Brussels II, Dr. Boris's. And can I ask you please to turn to page 13, 12 and 13. And beginning at paragraph 35, do you see a heading parental responsibility? Paragraph 35 simply recites, or paraphrases Article 3 of Brussels II. And then she says this, paragraph 36, the structure and content of this provision are the product of difficult negotiation, both within the community and in relation to worldwide provisions, particularly the 1996 Hague Convention. The fact that the Community Convention limits itself to children habitually resident in the member state facilitates its compatibility with the Hague Convention. The agreement between the member states to include this matter within the scope of the Convention simply transferred the problem to the establishment of grounds for jurisdiction, since while there were no problems where the child is habitually resident in the state whose authorities have jurisdiction in the matrimonial proceedings, the same does not apply to cases where the child is habitually resident in another member state. The problem is further complicated by the fact that Article 52.2 of the Hague Convention provides that the Convention does not affect the possibility of one or more contracting states to conclude agreements which contain, in respect of children habitually resident in any of the states parties to such agreements, provisions on matters governed by that convention. As a result, where both conventions are in force, and remember by both conventions she means Hague and the anticipated Brussels Convention, the convention to which this report relates will take precedence in respect of children resident in member states of the EU which are party to it, whereas the Hague Convention will apply to other cases. There are no problems in relation to Article 3.1, which establishes jurisdiction in a matter relating to parental responsibility over a child of both spouses, where the child is habitually resident in the member state whose authorities also exercise jurisdiction in the matrimonial proceedings. It needs to be made clear that in no case does that provision mean that it must be the same authorities in the state concerned who rule on the matrimonial issue and on the parental responsibility. The rule is intended not only to establish that the authorities deciding on both matters are authorities of the same state. In practice, there will be the same authorities in some states and separate authorities in others. For the purpose of the Convention, the only point of interest is that they be authorities of the same member state with due regard for internal distribution of competence. Paragraph 2 sets out the conditions under which the authorities of the member state exercising jurisdiction on the divorce also have jurisdiction to decide on parental responsibility, where the child is resident not in that state but in another member state. Both the following conditions have to be met. At least one of the spouses must have parental responsibility in relation to the child, and the jurisdiction of the courts must have been accepted by the spouses and must be in the best interest of the child. This provision is taken from Article 10.1 of the 1996 Hague Convention, which guarantees that there is no contradiction between Article 3.2 of the Convention under discussion and the relevant provisions of the Hague Convention. The relevant provision of the Hague Convention says practically the same thing, the only difference being that, in addition to requiring that one of the parents has the responsibility, it also requires that at the time of the commencement of the proceedings, one of the parents habitually resides in that state. The difference derives from the differing subject matters of the two conventions. The Hague Convention deals with protection of children, whereas the convention to which this report relates deals with matrimonial matters, and for that reason the parent's connection with the territory of a state for the purpose of determining jurisdiction in matrimonial matters is determined by the grounds set out in Article 2. Article 3.2 is designed to cover one particular situation in which the best solution is to use the same grounds as the Hague Convention. So the important point is that according to Dr. Boris, the terms of the original Brussels II regulation in this regard were effectively designed to facilitate compatibility with the Hague Convention.
Well, isn't the effect of Article 52 of the Hague Convention that where the two competing states are subject to another international instrument, which I think for this purpose would include the Brussels II regulation, it's that other instrument which prevails.
Yes,
And that is the
Mirror-
same solution as in Article 61.
yes,
So that's dealing with two member states, one of whom may be subject, or both of whom subject to
Yes.
the Hague Convention. The Brussels II revised trumps anything in the
yes,
Hague Convention. And then that would then make sense of 12.4,
yes,
telling you what to do when, what relevance the Hague Convention might have when it's a non-member state.
yes. In other words, the Hague Convention, well, when it's a non-member state that's not a
Yes.
signatory,
Yeah.
as Pakistan
Yes.
to the Hague Convention, then the deeming provision comes into play. And that illustrates, we say, that third state means non-member state.
If the third state is a Hague Convention country, then the Hague Convention applies as between the member state and the third.
Yes, but only insofar as the regulation the convention makes provision.
Yes.
And the Brussels II revised, because it goes beyond Brussels II into non-matrimonial cases, does not contain a mirror, does not therefore involve or require something which is compatible with Article 10 of the Hague Convention. Of course, the other point to make is that Article 8 and 9 of the Hague Convention contain a power which anticipates Article 15 of Brussels II. Article 15 is the provision, Brussels II revised. Article 15 of Brussels II revised is the provision which provides for consensual transfer between member states. And there are similar provisions as between contracting states in Articles 8 and 9 of the Hague Convention.
Was that in Brussels too?
No,
Only in the revised?
only in the revised.
And did Dr. Boras opine about the revised Brussels
No.
too?
Again, Lord Collins will correct me, all of you will correct me if I'm wrong. And then I look to Lord Collins. Obviously, first of all, as I understand it, there was no explanatory report preceding the Brussels II revised. There were various preparatory acts and comments from various bodies within the EU, but nothing of the status of Dr. Boras's report. Am I right, Lord?
As far as I know.
So, unhelpfully, that's why I'm struggling. But at any rate, that is a theory as to why it is drafted as it is. And my point being that if the existence of the power of consensual transfer between contracting states under the Hague Convention, it might be thought that would anticipate and deal in practical terms with the sort of difficulties that might arise where there were competing claims for jurisdiction, rather than having one country unilaterally declare imperiously, to use the phrase, imperiously seize jurisdiction in respect of a child who is not habitually resident, to deal with it consensually. That is obviously the way forward, one might think, and Article 15 anticipates that, but it doesn't arise in respect of countries that are not parties. Obviously, it doesn't arise in respect of countries that are not parties to the 1996 Convention. That, my Lord, completes all I had wanted to say about third state. Can I just report any further on that topic before I move to my next topic, which is the criteria for prorogation under 12.3.
Yes. Yes, I think you can move on. Thank you.
Article 12.3 of Brussels II revised specifies 3 criteria for the prorogation of jurisdiction by courts of a member state in matters of parental responsibility over a child, all of which have to be satisfied. Namely, 1, that the child has a substantial connection with that member state, Article 12.3a. 2, that the jurisdiction of the courts has been accepted expressly or otherwise in an unequivocal manner by all the parties to the proceedings at the time the court is seized, Article 12.3b, and 3, the jurisdiction is in the best interest of the child, Article 12.3b again. Now, as far as the first criterion is concerned, Article 12.3a, that is manifestly satisfied, and this is not contentious, because under Article 12.3, it's 3a itself. Article 12.3a specifically provides that a substantial connection will be established, in particular, by virtue of the fact that one of the holders of parental responsibility is habitually resident in that member state, or the child is a national of that member state. In this case, both of those exemplar conditions are satisfied, and consequently, as is agreed by all parties, the child has a substantial connection with this country. So,
Why should there be the alternatives? I can understand the first one because it has some bearing on enforceability. But the second alternative is rather detached from that. I don't quite understand, but anyway, there it is.
It's very common in European conflicts law for nationality to be a connecting factor. Isn't that
Absolutely.
correct?
Yeah.
We, of course, in the common law countries tended to go for domicile.
Yeah.
yes,
Habitual residence was the new kid on the block, so to speak.
yes.
But the civilian countries tended to go for nationality.
But there was parents, patriarch.
Yes.
I see.
Yes,
Well,
yes. The wardship
I
is actually an exception to that, yes.
I don't think I can add to that debate, lady, because I'm obviously been focusing on the more contentious aspects as far as Millennium Friend is concerned.
Quite right.
And so I turn to the other two hurdles which I have to get over. And the first is that the jurisdiction of the court has been expressly accepted or otherwise accepted expressly or otherwise in an unequivocal manner by all the parties to the proceedings at the time the court is seized. And there are two components of that which we need to consider. And the first I want to consider is at the time the court is seized. And of course, here there is a distinction between the issue is, does that refer to a specific event in time, meaning when the court is first seized, or a continuum of time, such time as the court is seized, such period of time. The Court of Appeal held that it meant the latter. It's our submission that it means the former. Although, crucially, of course, later events are relevant in determining the position at the outset of the proceedings. We rely on a number of points in support of our preferred interpretation. We submit that the word has been in Article 12.3b is more consistent with a specific point in time. We point to the fact that under Article 8, the same phrase is used. Article 8, the basic general jurisdiction. The courts of a member state shall have jurisdiction in matters of parental responsibility over a child who is habitually resident in that member state at the time the court is seized. It's our submission to the court that the contrary interpretation would drain any meaning or effectiveness from the articles, because the crucial purpose of a jurisdictional rule in our submission is to determine whether the court has jurisdiction at the start of the proceedings so that it can continue to determine the issue.
It's something that one determines ad limine, doesn't it? I mean, normally it's one of the first things you have to look at in order to decide whether the court can do anything, a preliminary issue.
Well, we submit that's right. And once acquired in our submission, the court retains jurisdiction during the currency of the proceedings, save in the absence of very clear provision to the contrary.
At the time the court is seized is used in that sense in Brussels Convention and in Brussels 1.
Brussels 1, yes,
It'd be difficult to see how Article 19 would otherwise work.
quite.
And I'm not a linguist, but I've had a look at the French and the Italian, and they both talk about the date at which the court is seized.
Do they? I did consider some aspects of the French, but not this particular point. And in terms of looking at what the impact would be, if in the context of this provision, which is at the point is seized as being linked to consent of the parties, it would open up the possibility of a party withdrawing consent at any point during the proceedings up to almost the delivery of judgment in theory, if they wanted to. If at the time the court is seized means during the currency of the proceedings, and you have to show unequivocal acceptance or agreement throughout that time, it would enable a party who was dissatisfied with the course of the proceedings to withdraw consent at any point.
And is the expression "and is in the best interest of the child" tested at the same moment?
My submission to the court will be that it is. And I'll come back. May I come back to that, my Lord? Because that is obviously a linked but different point. And if I can but towards the end of my submissions on this point, draw your attention back to the practice guide at page 12, so tab 2, page 12, reminding ourselves, of course, that this is only a persuasive authority. Actually, it's 13, I think. Top of the page, page 13. The question of jurisdiction is determined at the time the court is seized. Once a competent court is seized, in principle it retains jurisdiction even if the child acquires habitual residence in another member state during the course of the court proceeding. That, of course, is dealing with the Article 8 point. And in my submission illustrates clearly the points that I've been making. So, tab 2, page 13, top of the page. Now, one of the factors which influenced the Court of Appeal's contrary interpretation was that it would preclude any party subsequently joined to the proceedings from having any right to refuse to accept jurisdiction. Obviously, parties can be added to proceedings, all proceedings, not least family proceedings, and not infrequently are. And in this case, of course, the child, as we've established, was joined as a party to these proceedings. And Lord Justice Thorpe pointed out that if consent was confined to those parties who were parties at the outset of the proceedings, that would deprive a later joined party, and in particular a child through the guardian, of the right to object to the court's jurisdiction. Well, my Lord, our response to that is, that's right. It does have that consequence. And the fact that it has that consequence does not, in our submission, in any way undermine the clear interpretation and meaning of the phrase. Parties added later cannot object, in our submission, to the jurisdiction. Although, of course, they can, in this instance, under the Children Act, invite the court not to make any order in the proceedings to which they have been joined. So we submit that Lord Justice Thorpe is right, that it does have that consequence, but that it is the clear consequence of the interpretation which he has clear consequence of the interpretation, which we say is absolutely clear on the words of the document.
What are the kind of issues that would be likely to be raised, leaving aside the question of interpretation, which, assuming that we accept your approach to interpretation on other issues, I mean, are they something that would go to issues of fact as to whether there truly was a substantial connection sufficient to satisfy 3A, and the best interest of the child point in 3B? To be going to factual issues, would that be right?
Does your lordship mean that those are issues which the guardian would?
Well, I'm talking about the party who comes in later,
Yes.
assuming that the court is seized because the court is satisfied at the outset that the tests are satisfied, and there are the factual issues that I've mentioned, which presumably will have gone through the court's mind in deciding whether or not
Yes.
the jurisdiction was actually established. But if it is satisfied then, I just wonder to what extent facts are likely to really shift significantly if some other party comes in. The best interests issue, of course, is always open ground, and it would be an underlying question anyway for the court in deciding what to do on the facts.
Yes.
But I'm just trying to get a sense for the reality of somebody coming in later, and to what extent he or she would be prejudiced from presenting arguments that really matter on the issue.
Well, my point to the court is that they wouldn't be prejudiced on presenting arguments that really matter to the welfare of the child, and that's why I give the example of the no order principle.
Mm-hmm.
Sorry, why not? I didn't follow that.
Because they may not be able to object to jurisdiction, but under the jurisdiction, the court has a very wide discretion about what orders to make, and indeed whether to make any orders at all. And if the guardian, for example, in this case, felt that it was not in the best interest for the English court to make an order in respect of the children, he or she could make submissions to that effect, and the court could well adopt those arguments.
Well,
Isn't the real point whether a later coming party should be able to withhold consent and thus deprive the earlier parties, the original parties, of the agreement that they had made to submit to the jurisdiction of the court? Once you put it that way, the other would be that the later coming party is stuck with the consent that the earlier parties have given.
Well, that's
Now,
fine.
as between those two, which makes the most sense?
Yes. Well,
I'm not supplying an answer to my question, but
no,
that's what the issue is.
That is our point is that it would have that effect. And in essence, particularly we think of the guardian would not be prejudiced in any way by being unable to challenge the jurisdiction, because he or she could and would undoubtedly make substantive submissions on the right order to be made, and that order might
absolutely.
Order
Somebody
might well
coming
be
in
no
for the
order.
child can say, "Well, I don't think you should be deciding this because it's obviously ought to be decided in Pakistan, and it will be in the best interest of the child that it is decided in Pakistan, and make no order."
And the judge could make no order.
But that's a peculiarity of children proceedings.
Yes, it is.
Whereas, if you ask my question, that applies to all provisions of this nature, which will apply in other situations as well. Is it the original party's consent that matters, or has it, to which a third party, not a third country, a third party coming in, is stuck, or can the third party deprive the original parties of the jurisdiction to which they have consented? I appreciate there's a factual issue on whether they did consent.
In purely adversarial proceedings, one can see strong arguments why a party coming in should not be entitled. I suppose it could be argued that in the less adversarial, quasi-inquisitorial nature of children's proceedings, different principles may apply. But if, for example, a grandparent, as often happens, I know you're considering grandparents in due course in this court, if grandparents apply and seek leave to join in these circumstances, could a grandmother say, I'm applying to be joined in these proceedings so I can object to the jurisdiction? In our submission, that would offend a number of principles, but that's a hypothetical point in this case. That there is no substantive, in our submission, there is no real disadvantage to those who represent children, which was the great concern of Lord Justice Thorpe. There is no real disadvantage to those who represent children if they are deprived of the right to object to jurisdiction in the circumstances in this case, given their clear power to make submissions and recommendations to the court as to the nature of orders that should or should
Even
not be
though
made.
that would have the effect of objecting to the jurisdiction, wouldn't it? If the order sought on behalf of the child was that all these matters should be determined in the courts of Pakistan.
Well, yes, that's right.
It would have the effect, absolutely contrary to what on the face of this provision appears to be the meaning, if it has your meaning.
This provision,
but if you concede, that that would be the position.
Well, this provision only establishes jurisdiction under the Children Act.
Well, we'd be making the order, having considered the merits of the case,
Exactly.
wouldn't it? I mean, that's one advantage, I suppose.
It would have the effect also, wouldn't it, of altering in effect Article 15 and extend it to non-member states. Because the whole point about Article 15 is that the court has jurisdiction, but then there's a discretion. If there's some other court within the community, the court first sees can say, well, I have jurisdiction, but it'd be better for all these matters to be dealt with in the courts of Italy, say. That's what Article 15 is about. Now, in your analysis, you get to exactly the same result by your approach, don't you?
Article 15, with respect, my Lord, goes a lot further than simply say a court disclaiming jurisdiction. It provides for the orderly transfer of jurisdiction.
Yes, but it's all about to the courts of another member state. The effect of the concession you've made, if it's correct, and if it would be regarded by the European Court as correct, would be in effect to provide the same result on the application.
It isn't the same result, with respect. It isn't. What it is a court in the United Kingdom having assumed jurisdiction and having heard from everybody with an interest in the welfare of the child, applying Section 1 of the Children Act, i.e. that the welfare of the child is the paramount consideration, deciding that in the particular facts and circumstances of the case, it is in the best interest of the child for the UK court to make no order. It's not transferring jurisdiction to Pakistan.
But it could
it's
do
not
it.
ceding jurisdiction.
I follow that, but it could do all those. It could do all those things, which Article 15 is essentially focused on.
But it would do it in a very different way.
And
Well, possibly it would have the same practical result.
On the wording of Article 15, it can't be operated unless the court actually has jurisdiction, because it says the court having jurisdiction as to the substance of the matter. So, I mean, the practical effect may in the end be exactly the same, but it's just a means of addressing the problem which you're having to face of getting through the hurdles to get through to Article 12 as the proper one.
Well, yes.
But can I ask you just one final point, and that is on the factual matrix that one to be looking at. Assume that since the date of first seizure, if that's if one's looking at that as a point of time, a particular date, there's a change in the habitual residence by the one person with parental responsibility who satisfied the test at the beginning. Suppose there's a change later on. That, I suppose, is a factor which could have a bearing on the order the court would make at the end of the day anyway, because presence of parents in jurisdictions matters a lot to what orders you're going to make. So really the whole factual issue can be addressed as part of the substance, even although it isn't available as a point on jurisdiction.
Although it may be, my Lord, difficult for me to make the submission at the end of a long proceedings dealing with jurisdiction. Jurisdictional issues are designed to be resolved speedily, as speedily as possible, and without fuss, and without an undue examination of the merits of the case. If at the end of the day, jurisdiction having been found, the court makes no order, I quite take Lord Clark's point that the effect may be the same from the party's point of view as if the court had declined jurisdiction in the first place.
Because the test under Article 15, for example, is the best interest of the child at the time of the application, isn't it?
Yes.
That's not at the time of the first seized. Article 15 is focusing on the best interest of the child at the moment the application is made by the court which has jurisdiction, isn't it?
Yes. Yes. Well, my Lord, I'm going to come on to best interest and how I deal with that in a moment.
Yeah, I follow that, but it's very important because these things have to be considered in the context each of the other.
Of course. I would urge your Lordship, with respect, to be cautious about considering Article 15 as simply equivalent to a decline of jurisdiction. It is not a decline of jurisdiction. It's a far more complex process. as I call it, consensual transfer of jurisdiction. May I come back to best interests and how this impinges upon that in due course?
Depends what's meant by to hear the case.
Well,
You could transfer the hearing of the whole of the case
yes.
under Article 15, and that is limited. It's what I'm troubling me a bit about this analysis, is that while it has a certain forensic attraction, I can see that, it doesn't fit terribly well with the actual restrictions in the regulation.
Which restrictions in particular, my Lord, does your Lordship have in mind?
Well, for example, restricting Article 15 to courts of another member state.
Well, but this is the
Because
whole point.
by almost identical, by a different analysis, you can transfer the hearing of the case to Pakistan.
But, my Lord, the whole point of Article 15 is to create a framework for consensual transfer.
Yeah.
And that can only operate between those who are parties to the international regulation, be it this regulation or in the equivalent provision in the 1996 Convention. Yeah. You can't tie Pakistan to Article 15 until it signs it.
Could I just ask a question about Article 15? Can the state to which the case is to be transferred decline jurisdiction?
Yes. They can request it and they can decline it.
They are invited to cooperate.
They are.
Very unfortunate to go through all the process and find a decline, and the court declines.
Yes. Well, yes. I'll see if I can find an authority on Article 15. There is one.
I suppose they can decline it, although you'd have to consider how that fits in with the doctrine of mutual trust. It seems to me that it's well known one of the principles which we all know underpins these provisions is the doctrine of mutual trust. So if you have a court which has the jurisdiction, let me say the United Kingdom court, requesting another court to hear the case, then I'm not sure, absent some very surprising circumstances, surely the doctrine of mutual trust would require the receiving state to hear it.
Well, have we looked at it?
15.4 deals with that point.
It does. I mean, I was going to go through Article just to consider how it clearly is of interest. Yeah. By way of exception, I underline that, whereas the courts of a member state having jurisdiction, so it's after jurisdiction is established, as to the substance of a matter, may, if they consider that a court of another member state with which the court has a particular connection, I'm underlining words which may be of interest if one has a long discussion about this, will be better placed to hear the case or a specific part thereof, and where this is in the best interest of the trial, stay the case or the part thereof, and invite the parties to introduce a request, or request a court of another member state to assume jurisdiction in accordance with paragraph 5. Paragraph 1 should apply upon the application from a party, or of the court's own motion, or upon the application from a court of another member state with which the child has a particular connection in accordance with paragraph 3. A transfer made of the court's own motion or by application of a court of another member state must be accepted by at least one of the parties. So you can't do it if all the parties are against. The child shall be considered to have a particular connection if, and there's a list of 5 factors in 3, 4, the court of the member state having jurisdiction as to the substance of the matter shall set a time limit by which the courts of that other member state shall be seized in accordance with paragraph 1. If the courts are not seized by that time, the court which has been seized shall continue to exercise jurisdiction in accordance with Articles 8 to 14. So in other words, if they refuse the request or don't comply with the time limit, then the requesting court shall continue to exercise jurisdiction in accordance with 8 to 14. The courts of that other member state may, where due to the circumstance of the case, that this is in the best interest of the child, accept jurisdiction within 6 weeks of their seizure in accordance with paragraphs 1A or B. In this case, the court first seized shall decline jurisdiction. Otherwise, the court first seized shall continue to exercise jurisdiction in accordance with Articles 8 to 14. The courts shall cooperate for the purposes of this article. Now that's, in my submission, quite a complex and framework for what I've called consensual transfer from one court to another. It follows on, but in greater detail, the provisions of Article 10 of the 96 Convention, to which we looked at earlier. It's not the same as the UK English court saying, I don't think I'm the best place, this court's the best court, I'm going to stay the proceedings on the assumption the proceedings will be transferred to a non-member state.
I think another way of putting that, surely, is that the whole structure of Article 15 doesn't contemplate a once and for all non-reviewable decision. It's a provisional decision, and the final view as to whether or not it should be transferred will depend, among other things, on the reaction of the court to which it is proposed to be transferred, and therefore can be distinguished between a court in this jurisdiction declining jurisdiction.
Yes, my Lord, that's, if I may say so, a far clearer way of putting it than I was able to achieve.
There's an interesting example of the usage of the word seizure in the fourth line of paragraph 5 of Article 15. If you cross-refer to paragraph 1A and 1B, what amounts to seizure is either the request under A or the request, the invitation which leads to a request under A or the request under B. It's a single act, really, in each case.
Yes.
And that rather supports what you were saying about seizure when we were looking at 12.3.
Yes. Yes, and in addition, Article 16.
I was going to ask you about Article 16. Does that help us about what is meant by a court being seized, given that it obviously refers to a date when proceedings are instituted?
Yes, although I don't, my lady, think that it would entirely knock out the alternative interpretation, but it certainly demonstrates that in the context of the regulation, the focus is normally on establishing a point at which the court is seized.
Could I ask you, what do you understand the effect of the first respondent's argument to be on decisions taken by a court before the dispute about jurisdiction is raised? In other words, let's suppose a case which has progressed through various stages, various orders have been made, no dispute about jurisdiction has been raised, but ultimately a party, let's take the example of a party introduced to the proceedings, objects to jurisdiction. Now, what do you understand the effect of the first respondent's argument to be if it is the case that that can rob the court of jurisdiction? Does it invalidate the earlier orders?
Well, that would seem to follow, would it not, my Lord? But
that would be an interesting consequence in this case if that was so. Well, yes.
well, I'm sure, maybe.
Well, perhaps Miss Russell is getting advanced.
I think Miss Russell may have got the message that this is something she'll have to deal with. Anyway, then Mr. Devlin reminds me to refer to the decision in Bush and Bush. At paragraph 65 and 66, I set out some passages from the judgment of Lord Justice Thorpe and the judgment of Lord Collins.
Yes.
And the italicised sections may indicate that a specific point is considered. But anyway, my Lord,
It just reflects that seizing in all these European instruments means the initial assumption of jurisdiction by the court.
yes.
I mean, there are quite a lot of cases in the civil area, more generally, on that very point.
Yes.
Well, I was thinking of our Lugano Convention case,
Yeah.
where it was all about who got there first and how you defined what was meant by service.
Well, of course, who got there first is usually why this point arises.
That's right.
Anyway, my Lord, have I said enough about at the time the court is seized. Can I move to unequivocal acceptance?
Yes, I think you can. Thank you. So we're moving to, in your case, to paragraph 71.
That's right. And Article 12.3 requires that the jurisdiction has been accepted expressly or otherwise by all the parties to the proceedings. Could I turn to the report in Bush and Bush, which is at tab 25, because I want to quote the whole of the relevant passage of my Lord Collins's judgment. Tab 25 in Authorities, Volume 2.
Is it tab
No, it's not
25? I think it
Got the wrong
must
one.
be 26.
26.
I think.
Sorry. Now, this was a case involving Spain. And I don't think we need to look at the facts. It's the interpretation of this part of the regulation which concerns us. And I do want to concentrate on the Lord Collins's, Lord Justice Lawrence Collins, as he then was, at paragraph 53 on page 11. It is plain that Article 12(1)(b) of Brussels II revised, when it speaks of the jurisdiction being, quote, accepted expressly or otherwise in an unequivocal manner at the time the court is seized, is not simply referring to a mere submission in matrimonial proceedings equivalent to what would be an entry of appearance under Brussels I, Article 24. First, it is clear that it does not refer to acceptance of the jurisdiction in relation to matrimonial proceedings alone. It must refer to jurisdiction in matters of parental responsibility. Second, the emphasis is on the acceptance of jurisdiction expressly or in an unequivocal manner. This must mean that acceptance of jurisdiction of a court other than that of the child's habitual residence is not likely to be inferred, and that the paradigm case will be actual agreement by the parties at the time the matrimonial proceedings are instituted. And then your Lordship proceeded to recite recital 12 to the regulation in paragraph 54. The first point, my Lord, we need to consider here in 53, because in that case, that turned on whether the case turned on whether a acknowledgement of service, effectively, or whether the filing of a statement of arrangements amounted to, in divorce proceedings, amounted to consent. The court held not. The point I want to obviously concentrate on is your Lordship's observation. The emphasis is on the acceptance of jurisdiction expressly or in an unequivocal manner. This must mean that acceptance of jurisdiction of a court other than that of the child's habitual residence is not likely to be inferred, and that the paradigm case will be actual agreement by the parent at the time the proceedings are instituted. Now, my Lord, of course, the paradigm case is clearly agreement, and it's absolutely right, of course, that, as your Lordship observed, it will not likely be inferred in the absence of such express agreement. But in my submission, it is open to the parties in certain circumstances, which we say apply here, to indicate through their conduct that they have unequivocally accepted jurisdiction. But that conduct must be clear. In our submission, such conduct has been demonstrated by the father in this case.
By actings. By actings, you would say?
By acting.
Yes, I mean, agreement can be demonstrated either by an express exchange of documents, let us say, which may be suitable in some cases, but in other cases you can infer agreement from the way parties have behaved.
Yes.
And it does, as we all know, it does sometimes give rise to problems. If somebody wants to oppose proceedings on the ground that there is no jurisdiction, he's got to come before the court to do that. But one's got to be careful how you actually proceed. If you proceed along the way, quite a way into the case without taking the point, then it may be said, well, it's far too late. You can't take this point at that stage. It should have been done at the outset. But that's why, if it's to be constituted by actings, you've got to look rather carefully at what the parties have actually done to see whether that agreement can be inferred.
Quite so, my Lord, and we list in paragraph 73 in summary 5 of the acts that we rely on so far as the father is concerned.
Is it legitimate to take into account his much earlier application for permission to remove the child from the jurisdiction as throwing light on what he was doing in 2007 to
Well,
2008?
in my submission, it is, and in particular the undertaking that he gave to return the child. And the context is, and what difficulties there might be in enforcing the undertaking. The context is that he was allowed to remove the child and promised to return the child. And it's worth just looking at the terms of that undertaking, going back to Mr. Justice Headley's order, which is in that slightly unusual place in the court's bundle. Page, no, it's not. I've got the wrong one. Yes, it's page. No, it's not. Where is it? It's the wrong order. 27? Tab 7. Is it tab 7? No, that's the earlier order. That's the later one. Forgive us just a moment.
Do you mean the order?
The order to give him permission to remove from jurisdiction.
Well, that was at tab 25 of
Thank you.
Appendix 2.
Sorry, I'm sorry.
Yes, it was, as early as that. So we were back in 2004.
Yes. He undertook, when given permission to remove the child from the jurisdiction, he gave an undertaking to return Kadir when ordered to do so by this court.
So I'm so sorry, which tab is it?
25.
25.
In the large appendix.
My fault, I beg your pardon, thank you.
Essentially, you say he showed that he was accepting the jurisdiction of the English court
Yes.
to deal with matters of parental responsibility.
Yes. Yes. Certainly as far as well, why should I restrict it to contact? So I only have to restrict it to contact, so far as contact is concerned. But it's not restricted to contact. It is, in fact, to parental responsibility as a whole. And nor is it confined to the proceedings that were then extant, 2004 proceedings. It's when ordered to do so by this court. And that's the context in which you consider the subsequent behaviour, which we've summarised, in particular those matters we've summarised in paragraph 73. Now, I fully accept that one has to be cautious about looking at these in isolation, and one perhaps particularly has to be cautious about acts of a litigant in person. But nonetheless, a litigant in person is a litigant. And he attended and participated at the hearing, it's called the conciliation hearing before the Deputy District Judge, which resulted in the detailed defined contact order on the 12th of December 2007. He participated in the 2-day hearing before Mr. Justice Headley, which resulted in the detailed defined contact order that we've seen earlier today.
Well, that was his own application, wasn't it? Am I not right? I mean, he was asking... Sorry, I beg your pardon. Yes, he participated in Headley. Later on, he asked for that order to be set aside.
Yes, exactly. He subsequently issued an application to have that set aside. And then there are the position statements, which we looked at earlier, which he says the court has retained jurisdiction and the father accepts the court's jurisdiction, although adding a rider about the enforceability of any orders made. Now, in our submission, contrary to with respect to Lord Justice Thorpe's analysis, well, Lord Justice Thorpe said, whether judged individually or cumulatively, I am quite unpersuaded that anything the father has done within this jurisdiction amounts to unequivocal acceptance. It's our submission, we don't invite the court to look at the acts individually, but to look at them cumulatively in the context of the undertaking given in 2004. And we submit that it is manifestly unequivocal acceptance. It's only very, very late in the day that he seeks to challenge jurisdiction. Prior to doing so, he's given an undertaking to the court to return the child to the court, if ordered to do so by the court. He submitted to at least 2 defined contract orders. He's filed a position statement saying, I accept the court has jurisdiction, and he's made an application to the court himself.
If one focuses on the unequivocal nature of the acceptance, is it arguable that if he misapprehended that he had no alternative to submit to the jurisdiction, that might have something to say on the question of whether it was unequivocal.
Well, in my submission, no. The question is, do you want this court to deal with this issue? Not, do you want this court to deal with this issue under this regulation or under that act? Do you want me, the judge, to decide the issue about the future of your children?
So it's irrelevant that he believes he has no alternative at that time.
Well, it would be irrelevant if he believes he has no alternative, but how can one seek to establish whether that's the case or not? Ignorance of the law is no excuse.
Well, yes.
Is the position statement of the 2nd of March
Yes.
looks pretty clear
Yes.
and presumably is not being drafted without authority by his, I would have said, very eminently respectable counsel, who was perfectly well aware of the law and able therefore to give him advice about it.
This is tab 20.
In the same bundle.
Yes, I'm not saying that this arises in the present case at all. It's just that in my mind I'm asking myself, is it conceivable that it might be relevant that someone mistakenly believed he had no alternative?
Well, obviously it is possible that he may have that belief, and he may be mistaken in that belief, or an litigant may be mistaken in that belief. Why should it, though, my lord, affect the outcome?
Well, I think that one can immediately think of countervailing arguments, because the opponent has committed herself or himself
Yes.
to the adjudication of the court.
And in this case, we're looking at a child's welfare.
Yes, yes, indeed.
Several years on into the proceedings. This point was considered, actually, my lord, by Mr. Justice Headley in another case, the case of C&C, which is at tab 25 in the authorities bundle. So that's, in my copies, that's volume 2 of the authorities bundle, tab 25. We've got it is reported somewhere, but we've got the Lawtel report. And this is about a case in which a mother had been given permission to remove a child to Spain. Well, a lot of the cases involved Spain. And the father subsequently brought further proceedings in England for contact with the child. Paragraph 12 the father's counsel says this. He says at all times up to her letter last summer, the mother fully participated in these proceedings. At all material times she was represented and took no issue on jurisdiction, even though the children must have been habitually resident in Spain for many months. It is true that the wording is in an unequivocal manner at the time the court is seized. That cannot, he contends, be narrowly construed, since at the time of being seized, the issuing of an application, a respondent may well have no knowledge of the matter. He submits the court, absent express acceptance, and it is agreed that there is none here, must look at the litigation conduct and draw inferences from it. He submits there is only one inference here, and that it is now too late to object to jurisdiction of this current matter. Paragraph 16, halfway down the paragraph, line 7, given that Miss Harding cannot challenge the fact of the mother's participation in the proceedings, she's for the mother, including an application whilst acting in person for an extension of time, the question can be further refined, and I think this is my lord's point, can the mother be said to have accepted jurisdiction in an unequivocal manner if she had never appreciated that it was open to challenge? It is that question that I'm required to answer. It would be unreal to think that the question of jurisdiction has never occurred to anyone. And I interject there that in this case we know that it had. That said, however, I do accept Miss Harding's submission that no one ever saw it as a problem and thus that the mother did not specifically address her mind to an objection to it. In my judgment, the fundamental approach to this should be what inference should be drawn from the mother's litigation conduct. The answer to that is clear, complete acceptance. Then one should ask whether a failure to address the question of challenge vitiates what otherwise appears to be an unequivocal acceptance. I do not think it does. This case demonstrates a clear acceptance of the county court's jurisdiction, at least until late July 2006, by which time, at any basis, the court must be seized with the matter. Accordingly, it is then too late to object. In my judgment, the evidence demonstrates unequivocal participation in the proceedings and thus an acceptance of the jurisdiction. I do not think that the absence, as I am prepared to accept it was, of advice on her right to object should vitiate the unequivocal acceptance otherwise established. I am glad to reach that view in this case, as questions of jurisdiction should be resolved at the outset of the case and not on the eve of the final hearing. That point of policy also fortifies my view that the court should be looking at what the parties have actually done rather than the reasons or lack of them for doing it, absent, of course, fraud or misrepresentation. So that's the view of an extremely experienced judge at first instance, addresses the very point your Lordship was making.
The principle underpinned by a good whiff of pragmatism, because if you permit someone to assert late in the day that they didn't address the question of jurisdiction, you invite someone who sees what way the wind is blowing to come up with a specious point. Yes?
May I then turn, the Lord, to...
Presumably that would be subject to the doctrine of negligent or misrepresentation or fraudulent misrepresentation or something of that kind.
Indeed, as Mr. Justice Headley makes clear.
I mean, that could arise in the case of an express acceptance. You could say, sorry, I agreed to this, but I was completely misled, and ask for that agreement, that express agreement, to be set aside. So there has to be that that modification of the thing. It's not so tight it doesn't accept that kind of error.
No, that's right. It doesn't arise in this case.
But in this case, we don't have.
Can I assist the court further on that point? If not, I'll move to best interest of the child.
Thank you.
Now, here, can I just go back to the regulation itself at tab 1. So, 12.3b.
Is there any difference between the superior interests and best interests?
No. I understand that in some translations the same word is used, and there's authority, which I don't have at my fingertips, to indicate that the same word is they are intended to mean the same. It's in the practice guide. We'll find the passage for my Lord.
Yes, French and Italian say superior.
Meaning both. On both points. Lord Clark's point is that it's superior in 12.1 and best in 12.
In the English language.
Well, in Italian it's superior in 12.3 and in the French.
I've always wondered, my Lord. Perhaps I can ask you which language do they use first, and where do we start? Or is it all simultaneous?
Well, they're all equally authoritative, but I'm not sure. I imagine it was drafted in French.
French. I'm told most of it's French. So moving.
Superior sounds much more like our concept of the paramount interests of the child. The best is about talking about the difference between two or more alternative solutions, whereas superior or paramount is saying this is an overriding consideration, the interests of the child.
It would definitely be possible to distinguish, to mount an argument that there mean different things. But as I understand it, there's authority that they don't. I don't have my fingertips. I'll get it over the German. As my Lord Collins has said, the same word is apparently used in other translations. So why they couldn't have done in this?
I think what we haven't quite worked out is whether superior is used in little b.
Well,
it is.
It is.
Yes.
It is. Yeah, I see. Thank you.
Yes.
So why the goodness knows. Then moving to the point I want to make about 3 initially is to acknowledge the syntax point, namely that the phrase reads, the jurisdiction of the courts has been accepted expressly or otherwise in an unequivocal manner by all the parties to the proceedings at the time the court is seized and is in the best interest of the child. So the phrase "and is in the best interest of the child" in the sentence, in the clause, comes after the phrase "at the time the court is seized." It's my submission, however...
It's the jurisdiction which has to be in the best interest of the child, is it?
Yes. Yes. In my submission, the only reasonable and practical construction is that that falls to be considered at the time the court is seized, i.e. at the outset of the proceedings. And it's not something which falls to be considered at all points during the course of the proceedings. The reason for that is a purposive argument that the purpose of Article 12 is to enable the court to determine whether it has jurisdiction. And in my submission, it would be manifestly unworkable if the court were required, in the instance of any party, to review the question whether it still has jurisdiction at all stages of the proceedings. Either the court has jurisdiction or it does not.
Not least because the court has a personal responsibility, as you've demonstrated earlier.
Yes.
So the consequence of the argument being accepted would be that the court would, of its own motion, have to review the question of whether or not it remained in the interest of the child.
At every time.
Yes.
And of course, it is, and the Lord Clerk's quite right to remind me, the jurisdiction of the courts, the jurisdiction is in the best interest of the child. But that is very close to asking the question as to whether, as the welfare question, and it cannot be right in my submission at all points for the court to consider the welfare question in order to determine whether it has jurisdiction, since the point of establishing jurisdiction is to establish to carry out the welfare exercise. Now, in this case, of course, we're dealing with a country that is Pakistan that is not a signatory to the Hague Convention, and consequently 12.4 comes into play. And here we move into an element of some uncharted waters, an interpretation which we put forward without authority for discussion. This contains a deeming provision. Where the child has his habitual residence in a territory of a third state, which is not a contracting party of the Hague Convention, jurisdiction under this article shall be deemed to be in the child's interest.
May I take you up on your description of this as a deeming provision? It isn't. Deemed is clearly, by reference to the other language versions, meant to. It simply means presumed.
Well, I'm glad that you correct me in that way, Lord. I stand corrected, but as you will have seen, the waters are not as uncharted as I anticipated, because that is what we had deduced. The provision.
Well, otherwise, it would make no sense at all.
Yes.
Well, my Lord, the interpreter, I'm happy to hear that that's the meaning in other languages, because that's what we invite the court to say.
Well, that's really what you're saying in your case in
Our
78,
case is that it's a presumption.
Yeah.
The question is, which we, and again, maybe there's help from other jurisdictions on this point. What does it mean? We asked the question, what does it mean where it says at the end there, end of Article of 12.4, measures, jurisdiction on this article shall be deemed to be in the child's interest, in particular if it is found impossible to hold proceedings in the third state in question. The suggestion we put forward is that there is a presumption where there is a presumption if the child is habitually resident in the third state, and that it is irrebuttable,
Or particularly strong.
or particularly strong. If it's impossible, we would submit it must be very strong, if not irrebuttable, if it's impossible to hold proceedings.
Well, that's because you're influenced by the word deemed. But if you say, if it does mean simply presumed, then it just becomes a very strong element.
Well, one other view is that it can't be a deemed provision if it identifies a particular factor. If it's a deemed provision, well then that consequence flows. You don't have to identify a particular factor.
Yes. Well, it's our view that that would be manifestly unfair. So the submission we were putting to the court was that it should be presumed.
Yes.
If that's the interpretation, that's the word used in other versions, then no doubt that's something which this court will want to make absolutely clear.
So what then does it mean? What then does it mean?
Well, there's the question of whether the absence of the word best, which my learned friend Mr. Setright points out. But we respectfully wonder whether that is of huge significance. What it means is that where the child is habitually resident, as here, in a non-contracting state, it is to be presumed that that it is in the best interests of the child for the jurisdiction to be exercised under this article.
In where?
In this country. Prorogation is to be presumed to be in the best interest of the child.
And you're saying the fact that you've got best at one part and not here doesn't matter, that's the obvious sense of it, you say, do you?
Not if it's a rebuttable presumption. Best interests, we say no distinction. So the question, where does that take?
And this is derived from the unequivocal agreement, the presumption.
Well, not so much derived from, but as a
Well, I mean,
as
that's
a next
step.
So there are hurdles we have to get over. Unequivocal the first one is substantial connection. The second one is unequivocal acceptance. The third one is best interests. And in the case of a child who is habitually resident in a non-contracting state, that is to be presumed.
Under Article 12.4.
Under Article 12.4.
But there still has to be the unequivocal agreement.
Yes.
Yes. Yeah. So, I mean, that's the underlying basis for the presumption.
Basically, you've got people saying, we will submit
Yeah.
to the jurisdiction here, because the reality is we've nowhere else to go.
Yes. I don't, in this case, put it quite as strongly as that, but I do say that the presumption applies. Where does that leave us in this case? Well, of course, it wasn't argued in this way before Judge Barnett, but he did conduct a very similar exercise, the forum conveniens exercise, and reached a conclusion that he would not have been persuaded to grant a stay. Thus, he accepted that if he had jurisdiction, the courts of England and Wales were the correct forum for deciding the disputed matters about this little boy. In our submission, that analysis of Judge Barnett's underpins the presumption and doesn't in any way undermine it.
But subject to the point you made earlier, that all this is a matter of jurisdiction, that on the application, on the merits of the application, then the judge has an unfettered decision to say that it would be in the best interests of the child at the time he's considering the application
To be an order, to make an order.
To make an order that this question be determined by the courts of Pakistan.
No, to refuse to make an order under his jurisdiction. The impact would be the same. The impact.
Because I'm still troubled by the notion that. Of course, I see the logic of everything you said, but there's something quite striking about the difference between little b and little in paragraph 3 and paragraph 1. Paragraph 1 is all about agreement between the spouses. Paragraph 3 is about agreement between all the parties to the proceedings. And one wonders whether the European Court might not say to itself, well, that must surely include the child. And that there's something very odd about having these strict rules about jurisdiction in circumstances where it's not unlikely, at any rate in a case like this, that the child is going to be represented. But before the child ever becomes represented, the case on jurisdiction is lost. There's something very odd about that.
Well, my lord, the first point to make it is.
I quite see the logic of your case.
The first point to make it is not, with great respect, correct to say that it is. Well, I forget the phrase your lordship used. Highly likely. It's still relatively unusual, in my experience. And I looked along the road to see if I'm wrong. Very unusual for children to be joined as parties to private law proceedings. Particularly with all the problems.
That may be so here, but we're construing a European interest.
Quite so. And it is right that the impact of our analysis is that
the parties doesn't get a say on the crucial question of jurisdiction.
No, but she does get a say on the more important question of what order to make, and the effect, which is fundamentally what she's there for. She's not there ultimately to represent the parties on
jurisdiction. Is that the best interest question may already have been decided as at the first seized moment, and if there's no change of circumstance between the two, it may be very difficult to argue the contrary.
But ultimately, the best The jurisdiction point is only the preliminary issue. The main question for the guardian is, what is in the best interest of the child?
Including where should this question be determined?
Well, that may be a component of it, yes.
Maybe a critical component.
Maybe. But
That's the reason why these questions are so hard for.
maybe.
The real question in these proceedings is, should this child come to this country to see mum, and should that, in due course, be capable of developing into unsupervised contact with the child? That is the issue to which the proceedings are directed. Now, it's perfectly possible that a judge hearing that issue will say, for a variety of reasons, whatever my view about what would in theory be best, I think that it will be the best interest of this child if I do not make any order on that topic. For a variety of reasons. It could be partly because of the difficulties of enforcement, partly because there are other proceedings going on in Pakistan or whatever, partly because there are things that he doesn't know. There are all sorts of reasons why one might not make an order. It's not like ordinary civil proceedings where you have to decide one way or the other what the answer is. And I think that's the difference between children proceedings and other proceedings. It's a different set of issues at the time than the issue about whether it's in the interest of the child for this particular court, at least to hear the case.
That's right.
It wouldn't offend EWCA to say that, for a judge to say, it wouldn't be in the interest of the child to make an order for contact with the mother because the grandparents would refuse to allow the child to leave Pakistan, and I'm entitled to take account of that.
Yes. It's important for all judges dealing when it comes to dealing with practical questions about children to adopt a pragmatic and realistic approach. And if this appeal succeeds, it is only going to be the beginning of the story as far as the mother is concerned. The next stage in the story as far as the mother is concerned, because there are a number of issues arising, including those which are clearly troubling the law.
I think my Lord Collins approach partakes of a jurisdictional overview, although it may not be directed to that. I think my Lord Clark is concerned that criticism might be voiced if we shut out the child from participation in the jurisdictional issue. And your answer, I think, to that is that, in effect, that will be something that will be considered at the time when the ultimate question is addressed by the court. Is it in the best interest of the child that we should exercise the jurisdiction, or should we make no order?
Exactly. It is the exercise of jurisdiction. But practically, it is from the party's point of view, it is the same point. Can I just brought further the question of best interest of the child?
Well, that, I think, leaves the policy considerations, does it?
It does. And then, if you wish to touch on the form of evidence, I will. But first of all, the policy considerations. Now, when I go to the exactly what Lord Justice Forbes said, so this is the
Tab 2.
tab 2, paragraph 33.
Can I just ask you one last question by way of postscript from what we've just been discussing? Do you discuss the point we've just been discussing in your case? That's to say, what is permissible and what can not?
I do.
And if you maybe could just refer me to that.
I do say, I will. I do say that yes, paragraph 70. This is the point about the guardian on the law.
Well, what appears to be quite close to a concession that you will arrive at the same position on the merits, whatever the result of the jurisdiction question.
Well, what I say at the bottom of paragraph 70 is, part 6 lines up from the bottom. Mine is added later, they cannot object to jurisdiction, they can, of course, invite the court and exercise its discretion not to make any order in the proceedings. And I'll give an example of paragraph section 1.5. That's obviously we've developed that.
I thought paragraph 76 was probably as close as you came to making the point, because you're contrasting, I think, there the exercise of what is in the best interest of the child at the point at which you're considering jurisdiction with the what the court actually does when it carries out its assessment in the exercise of that jurisdiction. And that's the contrast you've been making. But of course it does, I think there is, I think Lord Clark is really saying, well, you may have sold the pass once you get to jurisdiction. One of the crucial points has already gone by the time you've got jurisdiction established.
I mean, I can see that if the best interest of the child's points just sort of look sniff analysis at the beginning, that's one thing. But if, when you come to the actual hearing, then you'll have a proper hearing with proper evidence. I mean, it's just a sort of, well, it's a presumption, or something like it. And so once you've established the agreement between the parents, who may have all kinds of other axes to grind, that's one thing. But when we come to look at the real interests of the child, we're back with a black sheet of paper.
Yes, we are back with black sheet of paper. It can't be right for there being an enormously long analysis on this point. Otherwise, jurisdictional arguments would take
Even longer than they already do. But you will at least have heard some evidence.
Yes.
I mean, on the whole, with jurisdictional arguments, evidence is not very common, or it's only directed to specific aspects of jurisdiction. Whereas when you're deciding whether it's in the best interest of the child for you to make an order or not, you will have heard and seen.
That may depend on what this court says in this case.
Right. So it's policy matters. Now, the judge of your justice thought.
Paragraph
33.
33, yes.
Paragraph 33, my last word is to emphasise that prorogation is dangerous to go. In a huge majority of cases, the supreme reach of any global accordance of international family law depends on the readiness of states to recognise that, save in exceptional circumstances, the habitual residence of the child dictates which state holds the primary jurisdiction. Nationality, domicile, or passing presence should not ordinarily divert from that clearly principled approach. In our very considerable dealings with Pakistan, we are highly dependent upon the upholding of the protocol, which was signed by the senior judiciary of the two jurisdictions in January 2003. We are approximately 1 million British nationals of Pakistani origin in this jurisdiction. Conflicted cases between this jurisdiction and Pakistan pass through my office at the rate of approximately once a fortnight. Can I interject that? Of course, as the court will know, your Justice Thorpe is the halo of international family justice. I think that is the context in which he makes that observation. In the vast majority of cases, we are appealing to the judges of Pakistan to recognise that welfare decisions belong to and are the responsibility of the courts of the child's habitual residence. I stress that although the protocol is largely directed to cases of wrongful removal or retention, the principle stated in the first paragraph is of general application. In normal circumstances, the welfare of a child is best determined by the courts of the country of the child's habitual ordinary residence. We can hardly expect the judges of Pakistan to honour the protocol beyond the immediate territory of our Dutch if we lay exorbitant claims to jurisdiction in relation to children who are essentially Pakistani. Now, the Pakistan protocol.
Why is it exorbitant if both parents have accepted?
Well, quite. First point. Second point, the protocol itself doesn't talk about it being the invariable rule, it's the normal circumstances. And that is entirely consistent with European jurisprudence and the regulation. We tentatively raise this question: is it appropriate for a court interpreting English law, which is what regulation is, to do so in the light of, or by having regard to, the importance of a protocol signed by the judiciary of two countries? It's been observed, and we've given the references in paragraph 85, there's been some concern about the legal status of the protocol. I'm not sure whether this court will want to delve too deeply into that question. We accept that the protocol plays an important part practical role in regulating and assisting in relations between the courts of the two countries, but it's a non-legislative agreement between members of the judiciary and should not, in our submission, be invoked to determine the construction and application of English law. The consequence would be that one group of litigants, those who are relying on Pakistani courts to respect jurisdiction based on habitual residence, are favoured at the expense of all parents, other parents who wish to choose the English court under the prorogation powers in Article 12. And furthermore, we say it puts risks putting the courts of this country at odds with the rest of Europe, thereby defeating the principal aim of the regulation.
I suppose you could say the protocol doesn't seem to have been signed by the Lord President of the Court of Session in Scotland.
Nor yet the Lord Chief
Or the
Justice
Chief Justice of Northern Ireland. That's a very good point.
So it was.
I think I have
They
to
weren't
own
even-
that there was a
they-
delegate from Northern
Yes.
Ireland, but without the authority of the Lord Chief Justice.
Well, there we are.
I don't know to what extent the court is assisted by my developing those points, or by looking at the criticism of the protocol. It's not. It's not.
Were there to be a policy choice available, which in questions of jurisdiction is not necessarily the case, in fact not likely to be the case, but were there to be a policy choice available, then the protocol and the good it brings and the negative effects upon the protocol would be relevant to the exercise of a policy choice, one might have thought. But that's a very different thing from saying that it isn't the slightest bit relevant to the interpretation of what Brussels II and the Family Law Act require.
Precisely. That's as far as I want to go, my lady, my lord. I don't, unless you wish me to go further into the criticism of the protocol, I won't.
But parts of it presumably would be no more than guidelines for the exercise of discretion.
Yes, indeed, arguably it all is.
If it all is, then it's beyond criticism.
Yes, I mean, we can see the nature of it in paragraph 84 of your case. I think you quote
Yes.
paragraph 1.
Of course, and Lord Collins and all the court will probably know more than I. There are a large number of, I imagine, of agreements of this sort, and so odd agreements between member states and other countries. Some, I don't know whether there are any other examples of judge-led.
No.
Judge-led.
There are some other ones, or one other at least, that's a bit like this, I think, or at least one other that's in the offing that's a bit like this. But this is not an interstate agreement.
No,
It's not a treaty.
It's aspirational, really, isn't it?
it is. Does the court? Can I ask whether this is something which is affected in any way by the very recent convention to which my learned friend Ms. Russell alludes, the 2009 convention? Is it something which this country should be reconsidering in the light of the obligations under that convention? Not for me to ask the question. Anyway, my Lord, I've taken, I think, the point as far as I want to. It's quite clear, with respect to Lord Justice Thorpe, that the impact of the protocol was something which was featured strongly in the mind of the Court of Appeal in adopting a narrow construction of Brussels II revised. In my submission, that was inappropriate. Now, unless there's anything else I can say to assist the court on that topic, the last topic in our case is forum non-conveniens.
I noted that in Ms. Russell's case, paragraph 25, she said she would not raise, I hope I've got this right, would not raise this is a primary argument. I'm not quite sure what's left of it, but I get the impression she doesn't put that as a very strong point in her favour.
No, she doesn't. Can I ask the court just to consider this question? If it's not taken today, in this case...
Well, I think it's right to say she hasn't abandoned it, but it's put in that way in paragraph 25, just to show that it's not the primary argument, and that
Yes.
that's some kind of a notice to us as to the importance of the issue.
Were it not to be raised today in this court, it could undoubtedly be raised at some future stage in this or any other proceedings.
Yes.
And it is a question
Yes.
which the court may feel needs to be addressed. Does the EWCA principle extend over to Brussels II revised? Of course, it doesn't arise in this case strictly because Judge Barnett ruled on the previous occasion that that forum non-conveniens, that he would not stay the proceedings were he to have jurisdiction. So it doesn't, strictly speaking, my first point, I suppose, is I rely on his decision.
Yes.
I suppose that's different from making no order. About staying. No, it isn't such a daft point.
No, it's not. I'm sorry.
There's a lot of confusion of thought in relation to this. I mean, I can't remember without looking at EWCA whether it's about staying proceedings or declining jurisdiction. I always thought if you were making an application on the basis of forum non-conveniens, in litigation generally, you were accepting the jurisdiction of the court, but you were saying that this shouldn't be exercised for this, that, or the other reason. And I'm a little concerned myself that the principles in EWCA might be used, at any rate in some future case in the ECJ, in relation to the substantive questions we were discussing earlier.
Yes.
I may say I'm fixated by that, but I'm concerned about it.
Yeah.
And looking at your skeleton, the difference between staying on the grounds of forum non-conveniens and declining jurisdiction on those grounds is, if I may respectfully say so, fudged.
Fudged, yes. Sorry.
I'm not inviting you particularly to go because we have to think about it, but I think there are some potential problems there.
I've always thought of them as separate issues. I mean, the forum non-conveniens is a Scottish concept,
Yes.
and if you're taking the point, it's regarded as a quite separate point from a plea of no jurisdiction.
Yes.
So, I mean, in effect, if you're going to argue that point, you've conceded the jurisdiction
Yes.
point, and you're now discussing whether the court with jurisdiction should send the case elsewhere.
Yes.
That's the theory.
What I'm not quite sure is whether EWCA, it analysing it quite that way. It may do.
Well, to look at it, to answer that question, we'll have to look at EWCA.
Well, EWCA was a stay case, and they said
My recollection is
it was
it was a
not
stay.
legitimate to decline to exercise jurisdiction on jurisdictional grounds.
In brief, my point, you have my points about the impact of EWCA in the written case.
One line you don't mention in a written case, but we're aware of from experience in the House of Lords, is the issue about arbitration proceedings. If you have an agreement which you wish to give effect to, which conflicts with the Brussels rules, I think the Court of Justice has ruled that you can't do that. The Brussels rules are mandatory.
Yes.
And it just emphasises the importance of that doctrine, but it also illustrates the wide-ranging effect it has. And I'm for myself, I would be rather reluctant to get too deeply into this in a case where it doesn't actually arise, unless I'm persuaded that we need to decide it in this case.
My point is simply that it is likely to arise.
But not in this case.
It doesn't arise in this case, and this again comes back to how this court now sees its role.
Well, it would need a reference, really, wouldn't it?
Well,
that's exactly
there was
what we
quite
did,
a
isn't it?
swift rejoinder from the European Court in the EWCA about. My submission
it's
is
a different context.
Yes.
it is a different context. My submission there is clear that the language, the mandatory language is the same, so that it is clearly applicable by analogy. We read, again, Lord Justice Thorpe in another case, Cook and Plummer, asserts that it's very unpopular, that it has problems. I don't know to what extent that is you share within the membership of this court. Nonetheless, there is concern at the bar that this problem is going to arise sooner or later, given the difficulty in getting this far, and given the importance of the Supreme Court establishing guidance where legitimately possible. We raise it for consideration if the court wishes to develop those arguments.
Well, you've covered it very thoroughly in the concluding paragraphs of your case, and I don't know, unless anybody has any further points to raise, we need any more oral argument on the point. Are you content with that?
Now, can I assist the court further? There is the question of habitual residence, which Mr. Devereux is going to deal with.
Well, we've decided we don't need to be addressed on habitual residence, if that's any comfort to Mr. Devereux.
I think it is both disappointment and...
You've done a lot of work on it, I'm sure.
Well, can I assist the court further at this stage?
Thank you very much indeed. Mr. Devereux.
My lord, great comfort and disappointment as well.
Thank you very much. Now, Miss Russell.
Thank you, my lord. My lord, if I may first return to the matter of Article 12.4 in particular and the term third state. And it is our strong contention that third state, within the context of Brussels II revised, refers to states within, member states within the European Union who are non-contracting members, non-contracting states to the Hague Convention.
Not parties to the Hague.
And it is within that context that they are described as third states. And I've set out, I think, briefly in our case some of the reasons why we say that. But if we look at the regulations themselves regarding the 2 points where third state is mentioned, and also looking again at the articles referring to third states, the first one is, of course, and the first mention is at 12.4. And we would say that the meaning there is that where the child has his or her habitual residence in the territory of a state which is not a contracting party to the Hague Convention, then the court, the indication is that it's presumed to be in the child's interest, particularly if it's not possible to hold proceedings in that member state, to hold proceedings in the state that the parties have agreed upon. And I'll return to the matter of agreement later. If one also considers Article 61, which deals with relations with the Hague Convention of 19th of October 1996. Again, at B of that particular article, it refers to the recognition and enforcement of a judgment given in the court of a member state in the territory of another member state, even if the child concerned has his or her habitual residence on the territory of a third state, which is a contracting party to the convention. And we would say that the question of the definition of third state has to be seen within the context of the convention as a whole. And when one considers the convention as a whole, the preamble and indeed the guidance, which I will again return to, it's clear that the objective is to create an area within the community itself to allow freedom of movement of persons, including to adopt the judicial cooperation in civil matters and the proper functioning of the internal market. Mm-hmm. So that is the context of this. And my Lord Collins referred to the fact that third state could be seen perhaps in the same way that one might refer to a third party. But if one looks at the council regulation in that way, it would be most unusual, we would submit, if one was, for example, looking at contract and third parties in contract, that third party would be bound by a contract that they were not party to, in the sense they had had nothing to do with creating the contract or taking on board any of the obligations of that contract. And overall, the thrust of our argument is really that it would be a step too far for the European community to assume, whether by agreement or whether not by the agreement of the parents, to assume jurisdiction over children who are lawfully resident in non-member states. And as an illustration, of course, in this case, we're considering a child that's habitually resident now in Pakistan. But as an illustration, one can imagine the reaction of states, of other states, perhaps, for example, the United States or the Russian Republic, to the idea that the European Union countries were claiming that they had primary jurisdiction, again, I say whether by agreement or not, over a child that was lawfully resident in their country. And that is if I can say so, my lords and my lady, the main thrust of our objection to that definition of third state. And we say that that is supported by, for example, the guidance to Brussels II revised.
Before you get to that, what in Article 61, what do the last few words of B about habitual residence on the territory of a third state, which is a contracting party to the Hague Convention, what do they add, if you're right?
Well, what we're saying there is that the third country is the country that the child is living in. It's a country that is a member state. It is a contracting party to the convention, but the other states are non-contracting, and that's the assumption of that particular article.
But if it refers to a member state, then all you need is A, don't you?
Yes, one can see that argument, my lord, but the fact of the matter is that there are numerous references to member states throughout capital M and capital S, and we say that this is just to differentiate between the other states that are being described in the earlier part of that paragraph, and it's as simple as that and no more complicated than that.
Is there anything in the preamble that helps us at all? We get in paragraphs 1 and 2 of the preamble the general background.
Yes.
Which I think is that because one's talking about, or one's envisaging an area of freedom, security and justice, there should be common rules.
Well, there's nothing, sorry to interrupt you, my lord, but there's nothing that is even indicates, we would say in the preamble, that this regulation could be said to apply to non-member states.
I mean, you've got 12, which talks generally about the grounds of jurisdiction.
Yes,
and,
but again, that's...
and talks about member states
yes.
there. But I don't think there's anything that actually goes outside member states in the general discussion, but that may be understandable because the whole point of this this particular measure is that it's in effect part of the treaty obligations between member states in relation to each other.
Yes.
And is setting a common standard which all of them undertake to observe in all matters relating to parental responsibility. And that means that when you get to, for example, some of the bits in the preamble about mutual recognition, which is indeed paragraph 2, you can do that because you've all been working to the same basic rules on jurisdiction.
Yes.
And therefore it's reasonable that if an order is made by one member state in accordance with those rules, it should be respected by others. And none of that is asserting anything beyond the width of the treaty. It's not actually saying that people who are not bound by it are in some way bound to observe its rules.
But what is being suggested here is that by agreement, and I don't accept that there was agreement by the parties, but that's a matter that I'll return to. But by agreement, parties can, in essence, impose the jurisdiction of member states on a non-member state where a child is resident, because that's the essence of what will happen. The court here will decide the case, and if the court decides, or the court in France or the court in Belgium will decide the case, and will then make orders which are to be carried out in a third country, or we would say in a non-member state, and that can't possibly have been within the remit or the consideration of the European community when it was drafting this regulation. There's nothing that indicates that it was. And yes, sorry, my lady.
That depends on questions of recognition and enforcement in the non-member state.
Yes.
And that surely is why such emphasis is given to the 1996 Convention, because that does deal with whether a non-member state may nevertheless be bound to recognise and enforce judgments in other countries. But in this particular situation, where we have a state which is not party to that convention, and you'll correct me if I'm wrong, but I don't think, other than the protocol, it is party, which is not a convention, it's not a treaty, it's not binding in international law or anything like that. There is no international instrument to which Pakistan is a party which binds Pakistan to recognise and enforce the orders made in this country. That may be a reason for a judge here to decide that it's not necessarily in the best interest of the little boy for courts here to be beating the air. Back to my Lord Clark's problem. But it's not imposing on Pakistan anything that Pakistan hasn't accepted, as I understand it.
It's not imposing in the sense that if the court here reaches decisions about a child and makes orders about a child, there is an imposition on the jurisdiction of Pakistan, or indeed any other country in the world. And I am saying that I think that this, and we argue that we say that this goes far outside the objectives of the regulation. And one of the other objectives that we would suggest that supports what we're saying is in paragraph 32 of the preamble. It says this article does not go beyond what is necessary in order to achieve the objectives as set out in the regulation and in all the preceding paragraphs of the preamble. And that objective is, as I said at the beginning, to create a mechanism for the European community to deal with and cooperate with civil matters that are necessary for the functioning of the, and I emphasise the words, internal market.
I wonder to what extent paragraph 4 is a reflection of pre-existing practice. And by that I mean not just pre-existing the later version of Brussels II, but predating Brussels II at all. If one thinks back to practice before we became member states and got involved in these things, the proposition which is set out in paragraph 4 might be said to reflect what, in extremis, if you like, a court might feel it ought to do, assuming that it was in a position to make some kind of effective order.
You mean 12.4?
I mean 12.4, yes, sorry, I beg your pardon, it's 12.4 I'm talking about.
Yeah.
I mean, it's a kind of saving clause, in a way, to deal with an exceptional situation, particularly fastening on the last words. If it's impossible to hold proceedings in the third state in question, we'll take the extreme case.
Yes,
you have a child
but then there's also the provision for children who are perhaps stateless or certainly present, but it's not possible to deal with their case in another country. And that's Article 13, based on the child's presence. And I would say that is the article that deals with situations of extremis, not Article 12.4.
Well, there are two examples, I'd say, of extreme situations. You know perfectly well where the child's habitual residence
like
is,
refugee,
but there is simply no system that can possibly answer the problem that needs to be addressed.
If my Lord looks at Brussels II as opposed to Brussels II revised, which is at tab 6,
yes.
it does talk about applying the regulation to nationals of non-member states, and we would say that that is, again, I'm at this stage, my Lords, I'm just looking at the term third state, and we would say that that's an example of a clear usage prior to Brussels IIR, which shows that when the drafters of these regulations are considering non-member states, that's what they say.
Sorry, where is that, please?
Sorry, it's at paragraph, I do beg your pardon, my Lord, it's at paragraph 8, and it's the first page of Brussels.
Yes.
This is of the preamble.
Yes.
Yeah.
And that the very absence of the use of that term in the guidance and in the regulation, except for those two specific points in 12.4 and in 61, again, we would say that's not by accident. If they meant non-member states, that's what would have been said, and that there's some indication from the way that language has previously been used that that is the case.
Why not say member state, if it's intended to confine it to member
Because
states?
because what we would argue is that the third state there that's being referred to, particularly if we look at the words of of Article 12.4, paragraph. In that paragraph which they discuss the third state, we would say what it refers to, that term third state, is a state that is not a member state, but a member state that is not a contracting party to the Hague Convention.
Well,
and
that
that's
could
why
perfectly
that
well
term,
have been said, couldn't it?
Another
could-
state instead of a third state.
Yes, but
Yes.
what we're saying, the implication of this use, meaning that it's non-contracting states, non-contracting to the conventions and to therefore subject to the regulations.
But why introduce the qualification third at all? As my Lord points out, the context would be far more suitable to the use of the word another.
It may be, but that's the term they've chosen to use.
But they very frequently use the term member state.
They do, and they used it. Sorry, I'm sorry.
Is there any example where they use the term state without member, but it's quite clear that it's confined to a member state?
No, they use the term member state, and there are, my lady, I'm ashamed to say that I cannot tell you. I'm sure that there are some. May I return to that once I've had another
It might be interesting to look at
it.
directives out of this context altogether and see whether the expression third state has been used in any other context. Whether that would give us infallible guidance is another question, of course.
Well, at a quick glance, it looks as though they're very careful all the way through Brussels to revision to use the word member state, where they mean member state.
But they also look at, in the guidance, and that's at tab 2, and I've referred to you at the beginning of that, when they're considering Article 12.3 and Article 12.4, and you've already been referred to that by my very learned friend for the mother. The discussions are about the, again, of course, the term member state is used. And the term member state is used throughout, except where it's saying that this article should be deemed to, and one presumes that's where my learned friend got the word deemed from, but shall be deemed to be in the child's best interest when the child in question is habitually resident a third state that is not a contracting state to the Hague Convention, to differentiate between member states who are and member states who are not contracting states to the Hague Convention.
Well, we've pretty well reached 4 o'clock, and I think you may be about to move on to a new topic.
I was, yes.
Would it be convenient to pause there?
Of
and
course,
we'll look
yes.
forward very much to seeing you tomorrow morning at 10:30.
Thank you very much.